Good afternoon. Welcome, everyone. My name is Jennifer Marshall, and I'm the Vice President for the Institute for Family, Community, and Opportunity here at Heritage. It's great that you could all be with us. We thank you for pausing on a day that's very busy, beginning of a busy week, to talk about an important issue. Next Tuesday, the Supreme Court is going to hear oral arguments in the case of Obergefell versus Hodges. The case involves 4 state marriage laws defining marriage as the union of one man and one woman. And the question before the court is whether the 14th Amendment requires states to recognize same-sex marriage. The decision is expected in June, and it will likely determine whether states remain free to recognize marriage as one man and one woman. Well, the case has attracted a lot of attention in the media, perhaps you've noticed, and we think that there is more to the debate than is being heard today. And that's why we're here to hear from Jean Scher and Ryan Anderson, who have co-authored a very carefully argued legal memorandum on the subject for Heritage. Their conclusion is clear. Nothing in the Constitution requires the redefinition of marriage. And today they're going to explain the logic of that conclusion. Jean Scher is a Washington, D.C.-based attorney who specializes in constitutional and appellate litigation. And he is particularly well qualified to speak to today's issue because he has recently taken on public service on the issue of marriage at some cost to himself. In 2014, Jean resigned as partner in a law firm to serve as Special Assistant Attorney General for the state of Utah to defend that state's effort to defend its marriage law. In that role, he argued the case before the 10th Circuit Court of Appeals, which affirmed the district court's ruling against Utah's marriage law. In October, the Supreme Court declined to hear the case. Jean has previously served as Associate Counsel to the President and as Law Clerk to Justice Antonin Scalia, and has handled dozens of cases before the U.S. Supreme Court, including 6 he personally argued. Dr. Ryan T. Anderson is William E. Simon Senior Research Fellow in American Principles and Public Policy here at Heritage. He is a co-author with Robbie George and Sharif Girgis of a book, What is Marriage, Man and Woman, a Defense?, which has been cited by Supreme Court Justice Samuel Alito twice in his dissenting opinion in the Windsor case in 2013. While he is most well known for his work on marriage, Ryan has applied his considerable intellect to a broad range of topics related to natural law and political philosophy, most recently for Heritage on the issue of physician-assisted suicide. A graduate of Princeton University, he earned his doctorate in political philosophy from Notre Dame, and his dissertation was entitled Neither Liberal Nor Libertarian, A Natural Law Approach to Social Justice and Economic Rights. We're going to hear from Ryan and then from Jean in elaborating the public policy purposes of marriage and the legal argument that is before the court. This is the reasoning that's found in their legal memorandum published by Heritage last month, which is available outside. But we hope you enjoy listening to Ryan and to Jean.
Great. Thank you, Jennifer, for the introduction, and thank you all for coming. I want to say a couple of things about the nature of this case, but then save the bulk of my remarks for the policy interest about marriage, what gets the state in the marriage business. And since Jean is the lawyer, the superstar lawyer, former Supreme Court clerk and Supreme Court litigator, I'll leave some of the legal arguments to him. But as Jennifer mentioned, 2 years ago, Supreme Court Justice Samuel Alito cited the book that I co-authored in a dissenting opinion. We're hoping that it'll be cited in the majority opinion this time around. But what Alito did 2 years ago was he helpfully framed the nature of this debate. He said there are 2 different visions of what marriage is. There's the consent-based vision, and then there's the conjugal vision. Consent-based vision says marriage is about consenting adult romance and caregiving, and therefore the gender of the parties doesn't matter. Sexual complementarity is irrelevant if you think marriage is about consenting adult romance and caregiving. He said, but then there's this other vision of marriage. Marriage is about a comprehensive union of sexually complementary spouses. It brings together a man and a woman as husband and wife to then be mother and father to any children that their union might produce. He says there's nothing in the U.S. Constitution that tells us which of these 2 visions is the truth about marriage, that both of these visions of marriage have good arguments on their side, and where there are good arguments on both sides of a political debate, our constitutional system leaves the resolution of that debate to the people and their elected representatives. What Alito said 2 years ago with the federal policy on marriage is even more true of the state definition of marriage. And I'll leave some of those legal arguments to Jean to highlight. But the point here is that there's nothing in the US Constitution that requires all 50 states to redefine marriage. The Constitution is simply silent on whether the consent-based vision of marriage or the comprehensive vision of marriage is the true definition of marriage, and it's silent on what purposes the states should devise their marriage policy to serve. And since there are good arguments on both sides of this particular debate, unelected judges shouldn't simply insert their own policy views about marriage and then declare them required by the Constitution. Doing so would be akin to Roe v. Wade. There was nothing in the Constitution that required all 50 states to legalize abortion throughout all 9 months of pregnancy, and unelected judges shouldn't have said that the court or the Constitution required them to do so. So that said, let me move to the policy discussion. Why should the states continue to define marriage as the union of a man and a woman? Why are there good policy reasons for marriage to be defined that way? The basic argument here is that the state's not in the marriage business because it cares about your love life or my love life, simply because government's a sucker for romance. If marriage was simply about consenting adult romance and caregiving, we could get the state out of the marriage business. We could take the government out of our bedrooms. The reason the state's in the marriage business is that the union of a man and a woman can produce a child, and that child deserves both a mother and a father. That whenever a child is born, a mother's always close by. She'll normally be in the same room. That's a simple fact of biology. The question for culture, and therefore the question for law, is will a father be close by, and if so, for how long? And marriage is the institution that societies all throughout human history and all across the globe devised to maximize the likelihood that that man commits to that woman, and then the two of them committed to each other commit to raising that child. That when this doesn't happen, the social consequences run high. They run high for those children and for the community at large. One of the best ways of illustrating this is to read simply a quotation from President Barack Obama before he evolved on the marriage issue. He helpfully characterized the social science on this issue. Here's what President Obama said. He says, quote, "We know the statistics. Children who grow up without a father are 5 times more likely to live in poverty and commit crime, 9 times more likely to drop out of schools, and 20 times more likely to end up in prison. They are more likely to have behavioral problems or run away from home or become teenage parents themselves. And the foundations of our community are weaker because of it." End quote. Now, same-sex marriage didn't cause the breakdown of the family. Same-sex marriage is a consequence of the breakdown of the family. The vision of marriage that has informed many heterosexual relationships over the past 40 years is the consent-based vision of marriage, that consenting adults should do what consenting adults want to do, and that marriage is simply the union of consenting adults. If you think that the past 40 years of marriage practice has been a good thing for the United States, then you might want to see that vision of marriage formally and legally inscribed in our laws. You might even want to say that the Supreme Court should once and for all inscribe it at the constitutional level. But if you think the past 40 years has been problematic for the American family, that the breakdown of marriage, the increase of out-of-wedlock childbearing, the more than doubling of the divorce rates have been a catastrophe for America, especially the least well off in America, you might not want to rush in to legally redefining the central institution of civil society. You might think that this is something we should go slow on and that we should leave it to the states to make marriage policy. President Obama, in a different address, explained why he cared so much about the importance of fathers back before his evolution. He said, quote, "I have tried to be for Michelle and my girls what my father was not for my mother and me. I want to break that cycle." End quote. So President Obama knows firsthand what it was like growing up without his father involved in his life and the challenges that that posed for himself and for his mother, which cautions us to say that this doesn't mean that if you grow up outside of an intact married mother and father home that you're somehow destined for failure in life. President Obama has clearly led a successful life. But he himself would be one of the first to say that he had a tougher road ahead of him in life precisely because of the family structure into which he was born, and that's what has inspired him to speak out about the importance of fathers. That quote I just read was from the commencement address that he delivered at an all-male, historically black college, encouraging those male graduates to be good fathers and to be good husbands. But if you redefine marriage to say that it's the union of any two consenting adults, irrespective of sexual complementarity, how will we as a community insist that fathers are essential when the laws redefined marriage to make fathers optional? That's the challenge that faces a society that redefines marriage to make it simply about consenting adult romance and caregiving, and eliminates the public message of marriage that it's about uniting a man and a woman as husband and wife precisely so that children will have both a mom and a dad. And there are good reasons for the states to be able to take this slow. If Massachusetts and California choose to redefine marriage, the 4 states in the Sixth Circuit, which democratically chose not to redefine marriage, can wait and see what happens as a result. There's no need for the court to push a 50-state solution prematurely before we have all of the evidence in. And the reason I mention that is that there are several amicus briefs filed this time at the court that present new data and new voices that simply didn't exist 2 years ago when the courts were hearing these cases. There's an amicus brief filed by over 100 scholars of the family that point out that every nation and every state that have redefined marriage have seen their marriage rates decline by at least 5% after that redefinition, even as the marriage rates in the rest of the states remain stable. So in the United States, the states that have redefined marriage have seen their marriage rates as a whole decline by at least 5%, even as the national marriage rate stayed stable. The argument of these 100 marriage scholars is that it's only a society that already misunderstands the nature and purpose of marriage and that has devalued marriage that would redefine marriage. And then in turn, the redefinition of marriage sends the public signal that marriage simply isn't that important, which in turn leads to, it can explain that at least 5% drop off in the marriage rate. When you then take a step back and think, what does a 5% reduction in marriage over the course of a generation result in? They crunch the numbers. I think it's 600,000 additional children born to single mothers and several 100,000 additional abortions. So there are reasons to be concerned that as we change the definition of marriage, it'll shape our culture and how we understand what marriage is, which in turn shapes our beliefs about marriage, which then in turn shape our actions about marriage. We've also seen this time around, there are several amicus briefs that have been filed by the children of gay and lesbian couples. These children speak out about how much they loved their 2 moms or their 2 dads, but how much they wished they would have had both a mother and a father, and how redefining marriage will send the signal that 2 moms or 2 dads is the same thing as a mom and a dad. One of the most touching portions of these amicus briefs to read is when they say that if you take the example of single parenting or adoption or divorce divorce and remarriage, if a child experiences struggles in those situations and gives voice to those struggles, they're validated by their schools and by the press and by society as a whole. We're willing to acknowledge that if you're a child who's gone through a transition and you've been adopted or your parents have gotten divorced, you're raised by a single mother, that there's a missing mom or dad and you give voice to the pain that's caused you, we as a society will validate that experience. These children of gays and lesbians say that in a society that has redefined marriage, they've been told that the problem is with them. That if they experienced their family structure growing up without a mom or a dad as something that was challenging, it wasn't the fault of the family structure, it was their fault for interpreting it that way. And so it invalidates their experiences and their voices. And so they, in particular, encourage the court to look at all of the voices of children in same-sex relationships, including those who are concerned that redefining marriage would actually increase the harm of children just like them. So I've spoken for my 10 minutes. I'll stop here and turn it over to Jean, who will add some of the legal insights and some of the additional arguments that some of the amici made before the court. Thank you.
Well, thank you, Ryan and Jennifer, and I want to thank both Ryan and Jennifer and Heritage for their steadfastness in defending traditional marriage and in helping to coordinate all the people, all the groups who have an interest in doing that. And I think they play an enormously valuable role in our country. If I were a Supreme Court justice, and my position on same-sex marriage has now ensured that I will never, ever be considered as a candidate for Supreme Court, but if I were a Supreme Court justice, I would be very reluctant to create or recognize a constitutional right to same-sex marriage regardless of how I felt about same-sex marriage as a policy matter, and not only for the reasons that Ryan has just so beautifully articulated. These cases that the court has before it now are really an attempt to tempt the court to take away from the people their ordinary right in our constitutional order to decide difficult policy issues through democratic means. And past cases in which the court has succumbed to that temptation have backfired spectacularly. Ryan mentioned Roe versus Wade as an example. As Justice Ginsburg has noted now several times, Roe versus Wade actually provoked a political backlash that is with us to this day, and that probably slowed, or at least she believes, that Roe versus Wade ultimately slowed what was then a clear political march towards more flexible abortion laws. Another example, which Ryan and I discussed in our legal memo, goes back 150 years or so, and that is Dred Scott versus Sanford, which is another case in which the Supreme Court succumbed to a very similar temptation. Obviously, I'm not trying to compare same-sex marriage to either abortion or to slavery, but the politics and the legal analysis are similar. Now, Dred Scott in 1857 held that the federal government, and by extension the states, had no power under the Constitution to ban the holding of slaves, either in the territories or by extension in the states, in northern states, by people who had legally acquired them in southern states. And even though the constitutional argument was tenuous, Chief Justice Taney, who was from my state of Maryland, felt like this would be a good idea for the country. He felt like a decision like this could resolve the question of slavery and thereby sort of take it off the table politically, and he was hoping to avoid a war. Okay, and so he persuaded a majority of the court to adopt this pretty tenuous legal argument, and as they hoped, to prevent a wider conflict over the slavery issue. But as in Roe versus Wade, Taney's political judgment proved to be spectacularly wrong, and in fact his handiwork provoked such a political backlash that many historians believe that it actually contributed to causing the Civil War. And that's a fundamental problem with a decision recognizing a constitutional right to same-sex marriage. Not that it's going to trigger another civil war, but just as Chief Justice Taney misjudged the political climate in 1857, the Supreme Court today cannot possibly predict with any accuracy what the political backlash from a decision that takes away from the people such an important policy choice may be. And as Ryan mentioned, and as a number of amicus briefs demonstrate, recognizing a right to same-sex marriage is not only risky from a political standpoint, even if you're in favor of same-sex marriage, it also poses enormous risk to society, especially to children and to women from underprivileged groups. So with that brief background, let me talk about the legal arguments that are being made in the case. And every single one of these arguments has an obvious hole in it. Okay, and that's one reason that, as Judge Sutton noted in his opinion for the Sixth Circuit in the Obergefell case, he says, and correctly so, there has never been even an opinion written by a Supreme Court justice, any Supreme Court justice, that's held that there's a constitutional right to same-sex marriage. Okay, people on the other side assume that there are at least 5 justices who are prepared to rule that way, but not a single justice has written an opinion that says that. And in fact, there are 3 justices that have written or joined opinions that clearly say there is no constitutional right to same-sex marriage. And Chief Justice Roberts' opinion in the Windsor case goes at least halfway there. So, so as of right now, in terms of Supreme Court justices, it's 3.5 on our side, and nobody who's committed to recognizing a constitutional right to same-sex marriage. So each of the arguments is, as I said, has an obvious hole. Now, let's think first about the 14th Amendment, which of course is the basis for this claim that there's a right to same-sex marriage, the 14th Amendment was written and adopted by the states shortly after the Civil War. And I think it's, even though President Lincoln had already been assassinated before the 14th Amendment was adopted, I think it's useful to sort of look at the arguments here through the eyes of President Lincoln, who was an accomplished lawyer in his right. And it's useful to ask ourselves, how would Lincoln have viewed these kinds of arguments that are being made today? And so if somebody had gone to President Lincoln and said, look, we're about to enact this 14th Amendment, this language that protects rights to due process and equal protection, and somebody has suggested to us that maybe we shouldn't do that because 150 years from now it might be interpreted as creating a right of two people of the same sex to marry each other. Okay, imagine how President Lincoln, as a lawyer, not just a politician, but as a lawyer, would have reacted to that. He would have said, that's preposterous. No reasonable person could possibly interpret the language of the 14th Amendment in that way. And then as the politician in him would have said, now wait a minute, we've just fought this huge battle with the territory of Utah, to outlaw polygamy. And so you're telling me that this amendment that you're telling me will be adopted after I'm gone, you're telling me that this amendment would be interpreted in a way that would take away what we fought for in order to abolish polygamy. And in fact, when you look at the arguments in favor of same-sex marriage, if you were to take them to their logical conclusion, they would require recognizing a right to polygamy. I mean, if you think of the second potential wife in a polygamous relationship, she would arrive at the courthouse and make precisely the arguments that are being made in favor of same-sex marriage today. She would say, there's this man that I really love, and he's the only person that I love. He's the only person with whom I can be happy. And you've said that there's this general right to marry the person, the other adult that one loves. The other adult that I love, yeah, he happens to be married, but under the rationale of your decision, I have a right to marry him, just as one of the members of a gay or lesbian couple would have a constitutional right to marry the other. So Lincoln would have, as you can imagine, reacted quite negatively to that argument. And so the bottom line is that there has never been any general right, general constitutional right, or even a general right as a matter of state law or international law or anything else. There's never been any general right to marry the person you claim to love. And so a state's rejection of that claimed right couldn't possibly be a denial of due process under just the plain language of the Due Process Clause of the 14th Amendment. And then if we turn to the Equal Protection Clause, the other main portion of the 14th Amendment, the argument for same-sex marriage based on that clause also has holes in it. Unlike the old Jim Crow laws that prohibited miscegenation, mixed-race marriages, the man-woman definition of marriage doesn't offend the amendment's equal protection guarantee because it allows any otherwise qualified man and woman to marry regardless of their sexual orientation. Under the old Jim Crow anti-miscegenation laws, you were denied the ability to marry simply on the basis of your race. The state man-woman marriage laws don't deny anybody the ability to marry based on their sexual orientation. There's no question on the marriage application that asks, are you gay or lesbian? The law doesn't care. The law just says there are certain requirements for marriage, and if you're willing to comply with those requirements, then we'll give you a marriage license. And in fact, I think this point is brought home by another amicus brief that was filed in this case on behalf of 12 gay men who are married to women and who are raising families with those women. And they make the point in their brief that even though our sexual orientation presents certain challenges, we have made the choice that for us, marrying someone of the opposite sex is is what we want to do. It's the kind of life that we want to live. And the law has allowed those gay men to marry those 12 women, and without any problem, without asking them for their sexual orientation. So there's just the argument that there's discrimination on the basis of sexual orientation just doesn't work. Now, the fact that the institution of marriage, as traditionally understood, might be more attractive to some of a state's citizens than others doesn't mean that the state is violating the 14th Amendment simply because it refuses to redefine the institution to make it more attractive to more romantic partnerships. That's not the test for discrimination, and certainly not back when the 14th Amendment was adopted. Now, the other side in this legal debate makes a lot of U.S. versus Windsor, which Ryan mentioned earlier, and that was the decision from 2 years ago in which the Supreme Court invalidated the Federal Defense of Marriage Act, or at least the portion of the Federal Defense of Marriage Act that prevents the federal government from recognizing same-sex marriages. There's another provision of DOMA that has not been touched by Windsor, which is the part that applies to recognition of out-of-state marriages. Okay, that part of DOMA was not at issue in the Windsor case, but the part of DOMA that was an issue there was invalidated. But the grounds on which that provision of DOMA were invalidated was not because that provision denied gays and lesbians due process or because it denied them equal protection. The grounds on which that provision of DOMA was invalidated was because it impermissibly intruded into the authority of the states to define marriage. Okay? And in fact, every time that Justice Kennedy, who wrote the Windsor opinion, talked about why he was invalidating that provision of DOMA, it was tied to the authority of the state of New York to define marriage. It wasn't tied to any free-floating federal due process right or federal equal protection right. And again, every single time he talked about it, that was the ground for it. And yes, it's true that Windsor also talked about what some people call the dignitary interest of gay and lesbian couples and their children, and how the dignity of gays and lesbians and the children that they're raising would be undermined if their marriages were not recognized. But even that discussion in Windsor, every single time Justice Kennedy makes that point, it's also tied to the fact that what the federal government was doing in DOMA was undermining a dignity interest that had been conferred by the state. And that was the critical part of the reasoning in the opinion, was that this is a dignitary interest that was conferred by the state of New York, and we're not going to let the federal government undermine that dignitary interest because it's been conferred by the state. I mean, it was kind of like I analogize it to a takings case, right? Everybody knows that property rights are defined and created by state law, not federal law, but the federal takings clause in the Fifth Amendment and the 14th Amendment, the federal takings law clause says that the federal government can't deprive people of property interests that have been conferred by state law. And that was really all that Windsor was saying, was that the federal government similarly can't deprive gays and lesbians and their children of dignity interests that have been conferred by state law. And so the argument based on Windsor, for that reason, just to my mind, has a huge hole in it. Now, I talked earlier about the original understanding and meaning of the 14th Amendment, and especially the Due Process Clause. As the Supreme Court has interpreted the Due Process Clause since the adoption of the 14th Amendment, the Court has, in fact, allowed for some fundamental rights. Okay, over the course of time, the Court has held, for example, that there's a fundamental right under the Due Process Clause of parents to direct the upbringing of their children. Okay, and there are 3 or 4 other fundamental rights that the Court has recognized, including a fundamental right to marriage, but always in context understood to be the fundamental right to marry as state law defines marriage. not the fundamental right to marry anybody that you want. And the leading case on this fundamental rights due process doctrine is a decision called Glucksberg from about a decade ago, and that case involved an alleged fundamental right to assisted suicide. And the Ninth Circuit, which of course is always at the forefront of creating new constitutional rights, the Ninth Circuit had held that yes, in fact, under the Due Process Clause, there is a fundamental right to assisted suicide, and the Supreme Court said no, there's no such fundamental right, and they held further that in order to be considered a fundamental right, a right has to be so rooted in the nation's history and tradition that it has come to be, as the court put it, implicit in the concept of ordered liberty, such that neither liberty nor justice would exist if that right were sacrificed. And so clearly a right to marry somebody of the same sex does not fit that description, as the Supreme Court explained in Windsor. Justice Kennedy's opinion again acknowledged that including same-sex couples in marriage is what he called, quote, a new perspective, a new insight, obviously not something that's deeply ingrained in our culture and legal traditions. And therefore, under the reasoning of Windsor itself, there cannot be a due process fundamental right to marry somebody of the same sex. We've already talked about the gaping hole in the argument that the traditional definition of marriage constitutes discrimination on the basis of sexual orientation. There are also some people on the other side who argue that that definition constitutes sex discrimination because your ability to marry somebody depends on the sex of of your proposed marriage partner. Well, that argument also has just a gaping hole in it, which is that the man-woman definition of marriage doesn't discriminate against men or women, which is what's required for sex discrimination. There has to be some kind of discrimination that treats women as a class differently from men as a class, or vice versa. But the traditional definition of marriage obviously doesn't do that. It says to men as it says to women. If you want to get married, you got to choose somebody of the opposite sex. So it treats both sexes exactly the same in that regard. Well, I think with that I will just close and wait for your questions. Ryan has already beautifully explained why there is at least a rational basis for retaining the traditional definition of marriage, which is another argument that has made in the other, that's often made by the other side. So, just in sum. There are lots of good reasons, I think, why the Supreme Court, even for justices who are politically in favor of same-sex marriage, I think there are lots of compelling reasons why they would decide, let's just leave this to the states and let the states work this problem out through ordinary democratic channels. And one of the reasons is that the constitutional arguments that are made in support of same-sex marriage are just so obviously flawed that it's hard to see how anybody on the Supreme Court with a straight face could write a decision recognizing a right to same-sex marriage, especially in light of the language and reasoning in the last decision on that subject in Windsor. So with that, I'll look forward to your questions.
All right. If you would raise your hand, we'll bring a microphone to you, and if you would identify yourself and ask a question to one or both of the panelists.
Hello, my name is Josiah Lippincott. I'm an intern here at Heritage. My question is about, it's a great presentation, but my question is this. Does the Supreme Court have the power, as you say, Ryan, to even issue a 50-state solution? And here's my example. Obergefell versus Hodges comes before the Supreme Court. The court decides that in the 14th Amendment, there is in fact a right to same-sex marriage. Why is that then to be binding on every state as law? And the question I go back to is this whole idea that there is supremacy there, or even the creation of precedent. Article 3 gives Congress the power to control the appellate jurisdiction of the court. Why not return to that understanding that the legislature should make law? The state should make law, that the Supreme Court can decide the cases before it, but it is not able to make law for the whole country.
Yeah, I think that's a great question. On on a sound understanding of our Constitution and our constitutional system of government, all three branches of government and the states are co-equal branches. And they all have an obligation, they all take an oath to defend the Constitution, which means that they take an oath to interpret the Constitution and to implement it as they understand it. And again, Abraham Lincoln is instructive here. If you take the Dred Scott case, Abraham Lincoln said that in that particular case with those particular litigants, the Supreme Court's ruling was final, but that its ruling was not binding on his interpretation of the Constitution, and therefore he would continue to recognize free blacks as citizens. So, for example, he issued them passports. So he would not allow the Dred Scott decision to be binding on his administration, on how his administration understood the status of free blacks in the United States. He did recognize the legitimacy of judicial review. So I think what's important here is to say that judicial review is not the same thing as judicial supremacy. The court has a legitimate role in reviewing lower court decisions and reviewing challenges that are brought under higher law. So if you have a statute that might conflict with the Constitution, Supreme Court has a legitimate role in doing judicial review. The Supreme Court is not supreme, though, so judicial supremacy is the problem when it claims to be the only branch of government that has the obligation to defend and uphold the Constitution. All branches of government, both the three federal branches and the state governments, take that oath to defend and uphold the Constitution, and all branches of government are co-equal in interpreting what the Constitution means. What we're seeing here is frequently a dereliction of duty of the elected branches of governments deferring to the court, where they say, well, there's a court case pending, the Supreme Court will determine it. I think one of the greatest things about the Tea Party movement has been highlighting that all citizens have a stake in what the Constitution means, and all citizens get to participate in that discussion, and all branches of government have a stake in that. So one of the worst things from kind of a citizenship or a political point of view is when an elected member of government says, well, I don't know if it's constitutional or not. That's for the court to decide. No, the elected members of government need to know whether or not the laws they are passing are constitutional or not. And if the court gets it wrong, the elected branches of government are there to place a check on the court. We know that there are cases, Dred Scott, Roe v. Wade, where the court has clearly gotten the Constitution wrong, and it's appropriate for the other branches of government to place a check on them when they do so.
And I think this discussion illustrates the political point that I was trying to make at the beginning, which is that, you know, if the court rules in favor of the plaintiffs in Obergefell and rules that there is in fact a constitutional right to same-sex marriage, we are likely to see precisely the kinds of political fights that you've described. For example, you know, I suspect that we would see legislation at least introduced and pressed in Congress to restrict the appellate jurisdiction of the Supreme Court, right, in reaction to that. There would undoubtedly be a movement to enact a constitutional amendment on the subject of marriage that either would leave it to the states or would, you know, reimpose the traditional definition of marriage on all the states. So there are all kinds of potential political fallout from a decision by the Supreme Court on an issue like this, in which I think really the vast majority of people in the country believe that whatever the merits of same-sex marriage, it really ought to be a decision for the people. The latest poll on that subject, you know, showed public opinion running more than 2-to-1 in favor of letting the people decide, regardless of what people actually thought about same-sex marriage as a political matter. So there's going to be a lot of political hay to be made in tapping into popular resentment of the court for stepping into this issue, even among people who might think that as a policy matter, the court did the right thing.
Yes, here and then here.
Thank you. My name is Cláudia Trevisan. I'm a journalist from Brazil. Can it be an argument from the other side? The first question to Ryan, like to be argued that the ability to have a family that is created by two people that love each other increases exactly the possibility that you have more stable families. I'm not convinced by this argument that it would help society. And also for Mr. Jean, when you say that it can put at risk women, especially underprivileged women, could you explain more how it would happen? Thank you.
Sure, I'll take the first question and let Jean take the second. You're entirely right. That is an argument that could be made, and it's the argument that the other side is making. None of us have a crystal ball, so none of us know what the actual outcome will be. So there's the argument that if you create same-sex marriage, that it'll stabilize same-sex families and it'll lead to better outcomes for children being raised by same-sex couples. The counter-argument is that if you redefine marriage, you change marriage for all of society in a way that devalues marriage, and in a way that draws into question why the norms of monogamy, exclusivity, and permanency are requirements of marriage. The argument of the book that I co-authored is that sexual complementarity is the foundation on which monogamy, exclusivity, and permanency are built. That the reason that marriage is in an exclusive, permanent, monogamous relationship is that it's one man and one woman who can unite in the marital act that can create new life, and every child has one mother and one father, and marriage is about uniting those people in a stable, permanent, exclusive union. But once you say marriage is simply about consenting adult love and caregiving, why is that something that only two people can form? Why is that something that has to be permanent? Why is that something that has to be exclusive? So that's the counter-argument. The Supreme Court justices have no better ability than anyone else in America to predict what the outcome will be. They're not a super legislature. They don't have any greater policy insight. There's nothing in the Constitution that tells us which of those two arguments is the better argument. And that's exactly why Gene is right, where he says that this is precisely the type of issue that should be settled democratically. And what we can do is, frequently we hear that the 50 states are the laboratories of democracy. We can run a controlled experiment. We can let those laboratories of democracy do their work. And if Massachusetts and California redefine marriage, and if Ohio, Kentucky, Tennessee, and Michigan, the 4 states in the Sixth Circuit, choose not to redefine marriage, we can then see what the outcome is. Is it the case that the argument you made, that it actually creates increased stability and better outcomes? Or is it the case that my co-authors and I make, that it'll lead to increased instability and poorer outcomes? Those are the two arguments. None of us know what the outcome will be. None of us will know what the outcome will be if the court shuts it down prematurely. If the court kind of short circuits our democratic system and our federalist system from doing the work that it was designed to do, which is precisely why the court should respect the constitutional authority of states to make marriage policy. And then we can see, in the last week in the newspaper, I had said to a reporter that 50 years from now, we'll look back and I'll be proved either to have been prophetic in this prediction or to be an idiot. But we won't know which way that judgment comes out if the court doesn't allow us to carry through this democratic debate.
If I could just follow up on Ryan's answer before I answer the question that you posed to me. I agree with Ryan that nobody knows for sure what the impact of redefining marriage on children raised by same-sex couples will be, but I can tell you that the most recent evidence on that point is not encouraging, and it's counterintuitive. One of the amicus briefs that was filed in the case is a brief on behalf of an organization called the American College of Pediatricians, and also a couple of social scientists, including Professor Paul Sullins, who in fact has written a couple of articles on this very subject recently, and he concludes that when you take the study that has the largest sample size and the most plausible statistical techniques, and you look at whether kids being raised by same-sex couples do better when those couples get married or when they stay unmarried, his conclusion is they tend to do much worse when the couples get married. Now, you might ask, well, why is that? And nobody knows the answer to that for sure, but one possibility is that, the vast majority of social scientists tell us that children long to be raised by their biological mother and biological father. And so if you think of a child who's being raised by a same-sex couple, he or she may think, well, maybe this is just a temporary arrangement. Maybe things will change such that my biological mom and my biological dad will get back together, which is the situation for most of these kids, right? But if the same-sex couple actually gets married, that's a pretty clear signal to the child that your biological mom and dad are probably not going to get back together. And so you're probably not going to have the opportunity to be raised by them, and that in turn may create the kind of trauma that leads to the negative outcomes that Dr. Sullins found in his study on that subject. Now, again, it's a very preliminary answer, and as with all social science, it may be refuted in the future by something else. But it does tend, I think, to call into serious question the assumption on the other side, including the assumption by Justice Kennedy in Windsor that same-sex marriage is inevitably better for the children of same-sex couples that are being raised by same-sex couples. And let me now answer the question that you posed to me. Why is it that underprivileged women would be especially hard hit, or could be especially hard hit by a redefinition of marriage? I think the answer is pretty similar. Ryan is pretty straightforward. Ryan mentioned that in the states and nations that have redefined marriage to remove the man-woman definition of marriage, which is what you have to do to allow same-sex couples to marry, right? You have to remove the man-woman definition of marriage, and you have to replace it with a definition that says essentially any two otherwise qualified persons. So you make marriage genderless, whereas it has been an inherently gendered institution throughout society. And so what we've seen in both nations and states that have done that is a significant drop in opposite-sex marriage rates. Well, what does that mean then for women? What that means for women is if there's a drop in the marriage rate, that necessarily means that there's going to be an increase in the number of single moms raising kids. And what kind of women is that gonna hurt most? It's going to hurt women who are poor. Women who are already well off are not going to be hurt as much by not having a husband around to help them provide for and care for their children. But women who are relatively poor are going to be hurt much more by that. And that's why the effect of a redefinition of marriage would I think fall especially hard on underprivileged women. Just as a final note, you mentioned that you're from Brazil. I think it's interesting that if you look at judicial decisions around the world on the subject of same-sex marriage, and specifically on the question of whether the people or a court should be allowed to decide on that definition, there's only one court in the world that so far has held that a court gets to decide and the people don't. And it's the Supreme Court of Brazil. Every other court, including the courts in Europe and South Africa and every place else where this issue has been presented to a court for a decision, every place else the courts have said, no, this is a decision that's for the people to make through democratic means, regardless of what we think the right answer is. And that's established in an amicus brief that was filed by, I think it was 54 comparative and international law scholars. The two authors are Cole Durham and Lynn Wardle, if anybody's interested in that.
Great, thank you. Back here, and then we'll come to the back.
Hi, I'm Ariane DeVoe with CNN. Can you talk a little bit about this Sutton opinion? Do you see that as a roadmap, both of you, and why?
Sure, I'll let Gene take the bulk of that answer, but I think Judge Sutton did a really nice job with his opinion. He goes through all of the standard legal arguments that have been raised for why there might be a constitutional requirement that the states redefine marriage, and then he responds to each and every one explaining why they fail. So he goes through fundamental rights under the Due Process Clause, he goes through animus, he goes through equal protection, he goes through the Loving v. Virginia, the analogy to interracial marriage, he goes through rational basis, he goes through heightened scrutiny. He more or less takes each and every argument that the other side has made, and then one by one, he explains this is why it doesn't work, this is why it doesn't work, this is why it doesn't work, which is really an ideal piece of judicial craftsmanship, to take the best arguments that the other side presented and then refute them to explain why the arguments they make aren't coming to their desired conclusion.
And I think I agree with all that, and Judge Sutton also does something in addition that I think is very helpful, and that is he writes the opinion in a way that you can't really tell how he would vote if he were in the voting booth, whether to adopt same-sex marriage. He's written it in a way that's respectful to both sides of the debate, but basically doesn't imply or suggest any position on the merits, which is the way you would hope that a judge would write it. He's very much willing, both in the result and in his analysis, to leave the issue to the people without suggesting an answer one way or another. And I think in that respect too, it is a very good roadmap for whoever on the Supreme Court would write the opinion.
Let's take one in the back section, and then we'll come back down here.
Hi, my name's Eric Tietzel. Thank you, Jean, for your sound defense of the law that is built on, I think, a sound understanding of what marriage is. But my question is, it seems to me likely that a majority of the justices are going to buy into the consent-based view of marriage that Ryan described. If I'm right, and that's true, does the 14th Amendment require recognition of same-sex marriage?
No, I don't think so, because all 9 justices could believe in the consent-based view of marriage, but still say, as they should, there is another view of this, and if we're serious at all about federalism, and if we're serious at all about respecting democracy, then we still have to leave to the people the decision of which of those 2 different views they want to adopt in their laws.
Down here.
Hi, Dana Milbank from the Washington Post. You both made mention of this amicus brief in which the same-sex marriage has led to a drop in the overall marriage rate. Has that been established as cause and effect? And can you explain also I think that same brief says it leads to a higher abortion rate. Could you just go through that?
Yeah, sure. And I'm actually the author of that brief, but it is still too new to do a rigorous causation analysis using statistical methods. And so the best we can do is look at what has actually happened in the states and countries that have adopted same-sex marriage, and see if it and see what direction it points. And the brief doesn't even attempt to say conclusively that this reduction in marriage rates has been the result of adopting same-sex marriage. But what the brief does is articulate the theoretical reasons why you would expect a redefinition of marriage from a gendered institution into a genderless institution to lead to a reduction in opposite-sex marriage rates. And to see this, and the point is made a number of different ways in the brief, but the way of making the point that I think is most compelling is, imagine that you are, an unemployed male 25-year-old, okay, and and you have a girlfriend, and your girlfriend gets pregnant, and the question is, am I going to marry my girlfriend and raise our child together or not? And then same-sex marriage comes along, and all of a sudden the law says to you, as an unemployed 25-year-old male, the law says to you, we as a society don't really need fathers to have good, happy families and to raise children well, because we've now created a legal structure in which 2 women can get married. They can, through artificial insemination, one of them could get pregnant, they can have a child, they can raise the child together with no involvement from any male other than the initial sperm donation. We've now set up a legal regime that not only permits but facilitates that. And so the message, if you're this young 25-year-old unemployed male, and especially if you don't have some religious beliefs or some other reasons to believe strongly in the ethic of marriage, it's going to be much easier for you to say, marriage is costly. It's going to tie me down. I'm going to assume these obligations to this woman and this child and all of that, and it's just not worth it. You're going to be more likely to say that after a redefinition of marriage than you would be before, when society is telling you, albeit not very successfully today, but at least there is that message in the gendered definition of marriage that men and women are not fungible when it comes to parenting. and when it comes to raising kids.
Last row in the middle.
Thank you. My name is Hermes Levy. I'm from the OWS. Excuse me. I want you to comment on what I'm about to say. Maybe I'm an idiot also. The United States are founded on the natural law. The founding father were philosophers. The Constitution itself, whosoever have some training in philosophy, will find out the 7 hermetic principles. For me, it shouldn't be any debate, because if you go to the nature, you take electricity, you have a male, a positive pole, which is a male, and a negative is a female, that produce electricity. If you don't have it, we will not have any electricity. So, given those facts, should it even be a debate about same-sex marriage?
Yeah, great question. So I think you're right to suggest that our nation is founded on natural law and natural rights. The founding document of our nature is the Declaration of Independence, which articulates certain inalienable rights that are self-evident truths founded on the laws of nature and nature's God. And then the founders tried to give a governing effect to that governing philosophy in the Constitution. So the Constitution tries to protect the natural rights that the Declaration articulates. That said, neither of those documents tell us what marriage is. And so in that case, there really is a question of how do we as a self-governing society think through the question of what should our marriage policy be? I think that the founding generation of philosophers that were informed by natural law and natural rights would come to the conclusion that marriage is what they said it was back then, the union of a man and a woman, a husband, a wife, a mother, and a father. So that's just to say that I agree with you that from kind of a philosophically informed natural law, natural rights perspective, that's how we would arrive at that decision. But we don't have anything in either the Declaration or the Constitution that tells us that. The way that we got there was by making state marriage laws. 39 states, if the court decides the right way in this decision, have democratically enacted laws that define marriage as the union of a man and a woman, and there are 11 states that have chosen democratically to redefine marriage. Since there's no way apart from that democratic process of knowing what the natural law about marriage is, right? I mean, so the way that we as a self-governing community make laws, that we each as citizens, as philosophers, think, all right, well, what is the natural law about marriage? And then how do we enshrine that in our positive law? This is what Martin Luther King Jr. was doing in the civil rights movement. He said that segregation violated the natural law, and it was the job of statesmen to see the natural law vindicated in positive law. And so in his letter from the Birmingham jail, he cites both Augustine and Aquinas and says that an unjust law is a man-made law that's not in accord with the natural law. And his entire point was that we as a self-governing community need to properly interpret the natural law and then see it vindicated in our man-made law. And I think that's the exact same type of debate that we're now having about marriage.
Great. Well, I think that's a fitting end. I apologize that we're going to have to cut off the questions. We'll be hanging around for a few minutes if you want to engage either of our speakers in further discussion. Please do pick up the legal memorandum that Ryan Anderson and Jean Scher have written, which describes why there's nothing in the Constitution that requires the redefinition of marriage and why the Supreme Court should therefore allow states to be free to set marriage policy. All right, would you join me in thanking Jean and Ryan?